Welcome, everyone, to the Federal Bar Association Ketam Sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Chair of the Ketam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So, Tejinder, this episode is a little different from our usual fare. Almost a year ago now, on June 1st of 2023, we got the Supreme Court's decision in U.S. ex rel Schutte versus SuperValu Inc., a case that you argued successfully for the relator side. And today we'll survey 12 months worth of SuperValu applications and see whether things have played out as you imagined. But first, maybe, Tejinder, you could remind us just a little bit about what the Supreme Court actually said in SuperValu.
Sure thing. So SuperValu is a case about the False Claims Act scienter standard. And the specific question the court was called on to decide is, could the defendant negate a showing of scienter by showing that its conduct fell within a reasonable interpretation of the law the defendant was accused of violating? In other words, could the defendant say, yeah, we broke the law, but a reasonable person could have thought what we did was okay, therefore we couldn't have acted with scienter, no matter what the evidence actually shows about what we believed when we were breaking the law? Unsurprisingly, the Supreme Court said, no, that's not how scienter works. It turns in significant part, or it can be established by what you believe. So if you broke the law and believed you were breaking the law, you acted with scienter, even if a reasonable person could have thought that what you did was okay. So on its face, the holding is quite narrow in that all it really does is eliminate this sort of objective reasonableness safe harbor. But to get there, the Supreme Court analyzes how the scienter standard works, compares it to the common law of fraud, and says it's closely analogous, and gives, I think, substantial guidance about how the scienter inquiry ought to be framed going forward.
So, since then, we've seen a few dozen cases where the courts have applied SuperValu. Not yet a huge body of law, but certainly a start. I know you've got a big list of case names in front of you, but let's start with the general question. On its face, Tejinder, SuperValu was certainly a win for relators. I think everybody agrees with that, and for the government. But let's talk about what's been happening in the lower courts so far. What have we seen?
Yeah, so one thing that we've seen is that some courts have described it essentially exactly as I have. That is, they say it's a one-way ratchet. What it's done is eliminate a defense and therefore made it harder for defendants to escape scienter as a matter of law, made it more likely that these cases will go to a jury. A very recent case called Stop Illinois Healthcare Fraud versus Sayeed, this is from the Seventh Circuit, decided May 2nd, 2024, explains the case exactly that way. The defendant there had tried to rely on the SuperValu decision, saying, oh yeah, this is good for me because I didn't have subjective knowledge. And the court says, look, all the decision holds is that if you had subjective knowledge, you can't get out of liability by saying my conduct was reasonable. This makes it harder, not easier, to assert a defense. Defendant, you should not be raising this. There's a similar decision from the Central District of California decided earlier this year called United States versus Advanced Dermatology and Skin Cancer Specialists. Again, it says the same thing. It says what SuperValu does is narrow the range of defenses available. There are a few other cases that I think are generally helpful for plaintiffs, that is, relators and the government. The Seventh Circuit's decision in Heath versus Wisconsin Bell, so there were two opinions in this case that was superseded upon a rehearing en banc, but both said the same thing about scienter. These were written by Judge Hamilton, who originally was the dissenter in the Seventh Circuit SuperValu decision and therefore became the top dog when the Supreme Court reversed, and basically lays out the scienter standard of the common law fraud and explains, you know, you are going to find it harder to get summary judgment if you're a defendant after the SuperValu decision. And then also a circuit case. There's a Fifth Circuit case called United States versus Daniels. And this one's interesting because here the government itself actually sought summary judgment, and the Fifth Circuit affirmed, saying there was no reasonable jury that could find that the defendant lacked scienter when he falsely certified that a school had been in operation for 2 years when it hadn't. And so, this is a situation where I'm not sure Schutte made a huge difference, but it definitely took arguments away from the defendant about what might have been reasonable to think, although maybe the defendant there didn't really have a reasonable argument to begin with.
So let's turn to the District of Rhode Island. We saw Judge Foley revive a case by reversing her previous grant of a motion to dismiss, saying that she had applied a standard that was now defunct. That was on a Rule 59E motion from the relator. Tell us a little more about this case.
Yeah, I mean, it's a pretty straightforward application. The District of Rhode Island, the case is called United States XREL Ocean State Transit versus Infante-Green. And what's significant about it is I actually thought this is what you would see the most of. So when you have a Supreme Court decision that is pro-defendant, you will often see a rash of motions to dismiss or motions for judgment on the pleadings or summary judgment motions based on that. When you have a decision that's pro-plaintiff, you're unlikely to see as many motions filed, except in the circumstance like this one, where cases have been thrown out and then the legal standard has been clarified. And so it's nice to see courts taking the Supreme Court's holding seriously and saying, oh yeah, we gave the defendants the benefit of this objective safe harbor defense before, but we shouldn't have done that. We're going to do it differently, and without it, the case goes forward.
Any bright spots for the defense bar under SuperValu?
Yeah, the one most significant one, there was a recent decision, May 6, 2024, in the Ninth Circuit called Evans versus South Carolina Intergovernmental Training and Development Center. This is a decision in the Ninth Circuit. It's an unpublished decision, so not precedential, but there is a decent discussion of scienter and therefore defendants. The court finds in the defendant's favor, even after Schutte, and even when I think there's probably significant evidence that would have allowed a jury to say maybe they acted knowingly. So the facts of this case were that they were billing the government based on their budgeted costs as opposed to their actual costs. And their contract clearly said you have to bill based on actual costs. And they said, well, we didn't know we were supposed to do that. And the government had accepted payments, had accepted invoices using the budget-based billing approach before. And the Ninth Circuit said, yeah, it looks like they did that. It looks like you had this going for a while, so it's fine. And you couldn't have acted knowingly. And so that's probably the strongest case for the defense side so far. There's another decision from the Eighth Circuit called United States XREL Kraemer versus United Dairies, where what the court holds is that in this case, the plaintiff had filed a 28J letter saying, hey, Schutte helps us here. And the Eighth Circuit says you still lose because there's no evidence of subjective fraud. But then the court goes on to say that the defendant's interpretation of the law was objectively reasonable, and it cites now overruled precedent as if it's still good law. So that's an interesting question about whether the Eighth Circuit is going to be fully on board with what the Supreme Court did, and we'll have to wait and see.
So, Tejinder, you and I discussed SuperValu on the rounds immediately after the opinion came out, and one of the unanswered questions back then was, what about objective recklessness? Is that still a viable way to prove scienter under the False Claims Act?
Yeah, so what the state of play before SuperValu is that several courts of appeals had said that in the False Claims Act context, recklessness can be equated with gross negligence. That is, it can be established on an objective basis. And that was based on some legislative history of the False Claims Act itself that says pretty much exactly that. The Supreme Court in footnote 5 of the SuperValu opinion says, we're not going to take a position about whether that remains a valid path to scienter, but the emphasis in the rest of the Supreme Court's opinion is on subjective proof of scienter. That's how they debunk the objective reasonableness defense. And so far, no court of appeals that previously had embraced the objective recklessness standard has walked that back and said, oh, we're wrong and we're overruling our old precedent. And I don't think there would be a lot of basis for them to do so, because by leaving it open, the Supreme Court plainly did not overrule those precedents. The only example I've seen of a court talking about this so far is in Illinois. There's a case called People X Rel Diamond versus Henry Poole and Company, and it's an Illinois appellate case. And it says, look, before the Supreme Court decided SuperValu, we recognized objective recklessness. And the way we read SuperValu is to say that subjective scienter is sufficient but not necessary to establish that the defendant acted knowingly. And so we're not revisiting our prior law. That's, of course, a state case, not a federal case, but that's one data point. On the other hand, there have been some courts, the district courts in the federal system, that have now suggested the scienter standard is only subjective. There's a case called Scollick, X Rel United States versus Narula. This is in the D.C. District Court, saying that SuperValu stands for the proposition that the FCA scienter element is subjective, not objective. And then probably the strongest case, if you were a defendant trying to say objective scienter is not good enough, there's a case from the District of Kansas. This was decided in August of 2023, called United States X Rel Edalati versus Sabharwal. And in that case, the court actually denies summary judgment to the plaintiff. So it was an offensive motion for summary judgment by the plaintiff, which is pretty unusual and unlikely to be granted anyway. But the basis on which they moved for summary judgment is they said, look, the law here is really clear, it's unambiguous, we should win because this guy clearly broke it. And the defendant said, well, I didn't know. And the court even says it's not clear on what basis the defendant is saying he didn't know, but he's saying he subjectively didn't know. And despite all of the objective indicia that make it highly likely that he knew, it has to be resolved at trial. It can't be resolved at summary judgment. I think that's a pretty clear statement that the standard is going to be treated as a subjective one in that court and not an objective one.
Okay, so let's talk about the future. Where do you think the scienter debate is headed next post SuperValu?
So I think the trend will be largely what we've seen, more cases making it to a jury. I think we will continue to see fighting over this question about whether objective recklessness is an independent path to establishing the scienter element, or whether there has to be some subjective awareness that the defendant was doing wrong. Other than that, I don't see a lot changing, because as I said at the beginning, SuperValu mostly just took away a defense. And so what I hope to see is that that defense will just be conclusively interred for all time. And there won't be anyone saying, even though we knew we did the wrong thing, you could see how someone else might have thought it was okay.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.